Wills, why they're important to you. What I do as public administrator's office, and there's a public administrator basically in every county in New York State, is we take over the estates of people who die intestate or without family able to administer. Quite often, we'll get the wills of certain parties where the executors have passed on, where the family is unable to bring the will to probate for whatever reason. It's very, very important that somebody's last wishes are laid forth. Now, I know you've probably gone through some probate yesterday, and you did some elder law as well. But you need to understand what exactly happens when you draft these wills, and as well how easy they are to do for you, because everybody's going to want a will from you as an attorney. You know, you're all basically new attorneys, and everybody's going to go, okay, listen, I've got this problem, I've got this aunt, she's getting old, I've got to set something up for her. What I gave to you today were 3 wills. We're going to start with the first one in your packet that they handed out. These particular wills were wills that came to my office. They've got some kind of interesting stories behind them. And they're a basic layout for what you're going to do in real life. The first will deals with a little lady who died on the South Shore of Staten Island and left behind her boyfriend and her brother. This particular will starts off with our typical introductory clause, that she resided in Staten Island, and that she publicly and declared this to be her last will and testament, revoking all previous wills. Why is this important? Your introductory paragraph has to set forth that this is your will, this is your last wishes. If you don't revoke the previous wills, what happens? Then they come forth, and so I'll get this will from her boyfriend, and then I'll get another will from maybe her, she had a niece that came forward and said there might have been a possible previous will. Now they have to get read together if you don't revoke them. So revoking them is very, very important. We don't revive any previous wills, so once it's revoked forever, and she would have to re-execute, okay? Your introductory paragraph sets forth who you are, where you're currently residing, and this is where the probate process is going to happen. I had given you in the back of your packet, which we won't really get into today, I had given you the probate checklist for surrogates court. That's available on the court's website for you. When you're bringing these wills up, you'll be able to run through them and see that this particular portion is complied with. So, we've got our introductory paragraph. You also want to make sure that the will is set forth and that all of her debts and funeral expenses are provided for. That's usually your second paragraph. Why does this matter? This also matters if they have a pre-plan. And I would suggest a pre-plan. What happens in my job quite often is I'll get a lot of testators who have died. They're sitting in the morgue, unfortunately. They have no funeral plan arranged for. And if I have no one left in the family, nobody able to administer, I don't know how they want to be buried. I don't know where they want to be buried. I don't know what their last wishes are. This particular paragraph is very important. What this little lady did was she made it quite clear that her funeral arrangements were going to be made through a certain funeral home in Staten Island. She also made mention of the fact that she had a plot available at a particular cemetery. This was important because now we knew what her wishes were. Sometimes the wishes are cremation. If they're not in writing and there's no family member that's there that's able to set forth exactly what the testator wanted to do, then what happens is they could wind up either in city burial or they could wind up in an unmarked plot anywhere in Staten Island. And in the other boroughs, unfortunately, they usually wind up in city burial. So here, she laid out her funeral arrangements. And the funeral arrangements here were to be made by a certain funeral home. That funeral home had directed her over to the particular lawyer who arranged this particular will. We were able to set forth where she needed to go and how she was going to be buried. Next, we set forth that all of her estate taxes and any other administration expenses will be paid. They get paid out of the estate. The probate assets are those usual assets that come forth. The probate assets being your real property, your personal property, anything that gets liquidated. Checking accounts, bank accounts, jewelry that would have to be sold off, anything along those lines. Any other expenses that would come out of this particular situation, estate taxes, administration expenses might include the bills for probate. It might also include the funeral arrangements that would come out. Those are always your first paid. It would include any investigation that had to be had into her family life, and it would include any expenses paid on behalf of liquidating her assets. Next, we need to get rid of her property. You can do this now, or you can nominate your executor. What's important here? The important thing is to nominate the executor. You can include that in the third paragraph. You can include that in later paragraphs. It's important who we choose for executor. This little lady chose her boyfriend. This is a problem. She leaves behind, she was married, her husband had since passed on. She left her boyfriend as her executor. He was living in the house with her. The real problem with that was, when she died, the boyfriend never acted. So she remained in the morgue until the family contacted me. Family is sometimes very important simply because they want to see that you get buried.